Make the property problem disappear before the permit deadline. I didn't hear those words until weeks after my house burned. At 2:17 in the morning, I stood barefoot in my driveway and watched the home my father built collapse into a wall of fire. By sunrise, almost everything I owned was ash, and before the firefighters had even finished checking the hot spots, Cynthia Vale, president of the HOA next door, sent me another offer for my land. $75,000 for property worth more than 8 times that amount. She thought the fire had solved her problem. She thought my deed, the survey records, her threatening messages, and every document connecting her to a multi-million-dollar development project had burned with the house. She was wrong. I didn't threaten her. I didn't tell her what I did for a living. And I definitely didn't tell her where I kept the evidence. 3 weeks later, Cynthia walked into a county courtroom with an expensive attorney beside her, convinced she was finally going to get access to my land. Then the side door opened. The bailiff said, "All rise," and I walked in wearing a black robe. That was the first moment Cynthia understood who she had been threatening, but being a judge was in what destroyed her. The evidence she thought had burned was, my name is Daniel Mercer. For 27 years, I lived on 11 acres just outside the eastern boundary of Silver Ridge Estates. The house was a fancy my father built, most of it himself, in 1987. Back when that ridge was still pine trees, gravel roads, and open fields. After he died, the property came to me. After my wife passed away, it became the one place I had no intention of leaving. Silver Ridge grew around us over the years. Bigger houses, stone entrances, decorative streetlights, a clubhouse. But my land was never part of the development. I never joined the HOA. I never signed its covenants, and my deed contained no association restrictions. For years, nobody cared. Then Cynthia Vale became board president. Cynthia liked projects, not small ones. The kind with glossy architectural renderings, catered presentations, and numbers big enough to impress people at board meetings. Her centerpiece was something called the Silver Ridge Wellness Pavilion. A new clubhouse, a pool, an event lawn, a private overlook, and enough landscaping to make the whole thing look like a resort brochure. The price tag was about $4.8 million. There was only one problem: the county would not approve the final access plan unless Silver Ridge controlled a 30-foot strip along the southern edge of my property. That strip belonged to me. And according to every recorded deed, plat, and county survey I had ever seen, it always had. I didn't know how important those 30 feet were when Cynthia first walked up my driveway, with 2 board members behind her and a rolled-up site plan under her arm. She smiled like the conversation had already been settled. Then she pointed toward my fence. "We'll need this section cleared before construction starts." I looked at the red line on her plan, then I looked back at her. "You'll need to explain why you think you own it." Her smile tightened. She unrolled the plan across the hood of my old Ford and tapped the line with one finger. "This is the community access corridor. It's already been approved." "No," I said. "That's my property line." One of the board members shifted his weight. Cynthia didn't. She pulled another map from her folder. "This is the HOA boundary." I went inside and returned with a copy of the county survey. I laid it beside hers. The difference was obvious. Her line extended almost 30 feet into my land. The county line didn't. Cynthia gave the survey a quick glance and laughed. "You really think your old paperwork outranks the HOA?" I had spent enough years in courtrooms to know something about people who bluff, interrupt them, and they become careful. Let them talk, and they usually give you more than you asked for. So I asked one question: "Who told you this land belonged to Silver Ridge?" For the first time, she hesitated. Then she rolled up her map. "You've benefited from this community for years, Mr. Mercer. It's time you started cooperating." That was when I realized this wasn't a misunderstanding. She knew the maps did not match. She simply believed her authority mattered more than the public record. 2 days later, the first violation notice appeared in my mailbox: $250 for an unapproved fence modification. I hadn't modified the fence in 19 years. 3 days later came another notice: $750 for improper vehicle storage because my Ford was parked beside my own garage. Then came landscaping, exterior maintenance, an unauthorized shed. By the end of the month, Silver Ridge claimed I owed $6,800. There was just one problem: I was in Silver Ridge. So I didn't pay, but I didn't throw anything away either. I scanned every notice, photographed every envelope, recorded every date, and created a folder labeled Silver Ridge. Property interference. Then I backed it up online. Cynthia thought she was building pressure. I was building a record. At the next board meeting, she called me a non-compliant homeowner who owed thousands of dollars to the association. I waited until she finished. Then I asked the secretary, "Would you enter that statement into the official minutes?" Cynthia smiled gladly. That was exactly what I wanted. People are much easier to hold accountable when they insist on putting their claims in writing. About a week later, I came home and found 3 wooden survey stakes along my southern fence. Bright orange ribbon was tied to each one. The markers sat nearly 30 feet inside my property. A survey crew had been there while I was gone. The next morning, Cynthia emailed me what she called an updated community boundary survey. According to that document, Silver Ridge now controlled the exact strip the Pavilion needed. Convenient, I went to the county recorder's office and pulled everything attached to my parcel. The deed was unchanged. The subdivision plat was unchanged. There was no annexation, no easement, no transfer, no recorded agreement giving Silver Ridge access. Nothing in the public record supported Cynthia S. line. But while reviewing documents connected to the project, I noticed something else. Silver Ridge had already spent more than $80,000 on architecture engineering and preliminary site work for the Pavilion. Those invoices were dated months before Cynthia approached me. They were spending serious money on a project that depended on land they didn't own. That changed the question. This wasn't just about a property line anymore. Someone had made financial commitments based on the assumption that eventually, one way or another, my land would become available. The main contractor was North Star Development. One invoice also referenced a consulting firm called Vale Community Development. The name got my attention. State records showed the company had been created 18 months earlier. Its registered address was tied to property owned by Cynthia's brother. The agreement promised the consulting company a percentage-based fee if construction began before the end of the year. I didn't yet know exactly how Cynthia benefited from that company. But I knew enough to keep digging. I printed the records and added a new divider to my binder financial interest. A few days later, Cynthia sent me a formal offer, $110,000 for the strip. A local appraisal had recently valued that portion and its development value at more than $640,000. I declined with one sentence. "No, thank you." Cynthia called less than an hour later. At first, she sounded reasonable. She talked about community improvement, property values, families, the greater good. Then I reminded her that I wasn't a part of her HOA. Her voice changed. "You're making this much harder than it needs to be, Daniel." I said nothing. "You have an old house on an isolated parcel. No amenities, no association support. Nobody is going to pay what you think that land is worth forever." I let the silence sit. Then she said, "You'll wish you had sold while the property was still worth something." The call ended. 20 minutes later, she left a voicemail. This time she was less careful. "You have until the next board meeting to reconsider. Things happen to neglected properties. Insurance gets complicated. Counties condemn structures. I'd hate to see you lose your leverage." I listened twice. Then I made 3 copies. One went to cloud storage. One went to my attorney. The third went onto an encrypted drive kept away from the house. From that night forward, I stopped treating Cynthia like an aggressive HOA president. I started treating her like someone who might actually follow through on a threat. 4 nights later, one of my cameras sent a motion alert at 12:43 a.m. A dark pickup had stopped near my back gate. The video was grainy, but I could make out the North Star Development logo on the door. A man got out. He walked along my fence and disappeared behind the detached workshop for almost 6 minutes. By the time I reached the window, the truck was leaving the next morning. One of my rear cameras was dead. Its cable had been cut. That afternoon, I noticed a sharp chemical smell near the workshop wall. Something like gasoline. I called the sheriff's office. A deputy photographed the area and filed an incident report. We didn't have enough to prove who had been there or why. Meanwhile, Cynthia had started using different language at HOA meetings. My house was suddenly unsafe. My property was blighted. My outbuildings were a threat to neighborhood values. She even suggested the county might need to intervene if I refused to cooperate. First, she tried to buy the land. Then she tried to move the boundary. Then she threatened its value. Now she was creating a public record that made my home sound like a problem waiting to be removed. I upgraded the cloud backups, copied the sheriff's report, and sent another packet to my attorney. 2 nights later at 2:17 in the morning, the smoke alarm went off. The alarm woke me before the heat did. At first I thought it was a false trigger. Then I opened the bedroom door. Black smoke was rolling across the ceiling, thick enough that the hallway disappeared behind it. I grabbed my phone and moved toward the rear exit, staying low. By the time I reached the kitchen, I heard glass break somewhere on the workshop side. Then flames came through the wall. I didn't stop. I got outside, crossed the driveway barefoot, and called 911. Within minutes, the entire western side of the house was burning. The volunteer fire department arrived quickly, but the fire was already inside the roof. I stood near the road while crews dragged hoses across the yard. At one point, I started toward the house. A firefighter stopped me. There's nothing in there worth dying, for he was right. That didn't make watching it any easier. My father had built the dining table inside that house. The kitchen doorway still had pencil marks showing my daughter's height from the time she was 6 until she left for college. My wife's favorite chair sat beside the living room window. There were photographs I had never scanned, letters I had never thought to copy. By sunrise, most of it was gone. The stone chimney was still standing. Almost nothing else was. A fire investigator walked the perimeter while I sat on the back of an ambulance with a blanket over my shoulders. He asked about electrical work, space heaters, fuel. Then he asked whether anyone had threatened me. I looked toward the southern fence. I told him about Cynthia, the offers, the voicemail, the cut camera, the North Star truck. He stopped writing for a moment, then he asked me to send him everything. At 9:14 that morning, while firefighters were still checking hotspots, my phone buzzed. An email from Cynthia. She wrote that she was deeply saddened by my loss. Then came the second paragraph. Given the severe damage to the property, the HOA was prepared to revise its purchase offer, $75,000, $35,000 less than the offer before the fire. I read the email twice. Then I looked at the smoke rising from what used to be my home. My house was still smoking, and Cynthia was already trying to buy the dirt underneath it. She made one mistake. She assumed the house was where I kept everything important. It wasn't. The original deed was in a bank safe deposit box. The county survey had already been scanned. Every HOA notice was backed up online. The voicemail existed in 3 places. My attorney had copies of the financial records, and my cameras automatically uploaded footage to a remote server. The fire destroyed my house. It did not destroy my file. By that afternoon, investigators had Cynthia's threats, the North Star footage, the disputed survey, and both purchase offers. Then the fire investigation gave them something new. Samples taken near the workshop tested positive for an accelerant. The fire had not started where Cynthia had spent weeks, suggesting my old wiring made the property dangerous. It started near the same wall where I had smelled gasoline. Investigators obtained records connected to North Star. One payment stood out. A subcontractor received a large site preparation bonus less than 48 hours before the fire. The description was vague. The timing was T. Phone records also placed him in the area the night my rear camera was cut. His vehicle matched the pickup in my cloud footage. The story Cynthia had been building was starting to collapse. This was land she needed, a homeowner she had threatened, a contractor tied to her project, and a fire that suddenly made my property cheaper. Cynthia still believed she was one legal filing away from winning. 3 weeks after the fire, Silver Ridge filed an emergency petition seeking temporary access across my property for what it called public safety and community infrastructure. The same 30 feet Cynthia had wanted from the beginning. By rotation, the filing landed in the court division where I served. The conflict was flagged immediately under our procedure. It was going to be reassigned, but the recusal still had to be entered before the matter moved forward. Cynthia apparently didn't know any of that when she arrived. She came 20 minutes early in a Navy suit, with an attorney beside her and a thick binder under one arm. At 9 o'clock, the courtroom settled. The bailiff stood. All rise. The side door opened. I walked in wearing my robe. Cynthia looked up, then she stopped moving. Her attorney looked at me, then at her, then back at me. The color drained from Cynthia's face. For months, she had treated me like a stubborn old man who didn't understand authority. She had never bothered to learn what I actually did inside the county court system. Now she knew. I took the bench only long enough to put the conflict on the record. I have a direct personal and financial interest in the property involved in this matter. I am recusing myself. The petition will be reassigned immediately. That was it. I did not rule on her petition. I did not use my position against her. I did not threaten her from the bench. The first thing I did with real authority was acknowledge where that authority ended. Cynthia had spent months doing the opposite. For a moment, I saw relief return to her face. She thought my recusal meant she had escaped. She still believed the robe was the problem. It was T. When the matter returned before another judge, I was T behind the bench. I was beside my attorney. Cynthia sat across the aisle with hers. The first thing placed before the court was the recorded county plat, not Cynthia's survey, the actual recorded boundary. The line sat exactly where it had always been. Then came the timeline. Cynthia approached me about the 30-foot strip. Silver Ridge began issuing fines against land outside the HOA. A private survey moved the boundary. I rejected the first purchase offer. Cynthia threatened the future value of my property. Her voicemail played in the courtroom. Things happen to neglected properties. Insurance gets complicated. Counties condemn structures. Cynthia stopped taking notes. Next came the North Star truck, the damaged camera, my Sheriff S. report about the gasoline smell. Then the fire, 2:17 in the morning. And finally, Cynthia S. email 9:14 that same morning, $75,000. My attorney placed the two purchase offers side by side. The second offer was lower, sent while firefighters were still on my property. Nobody needed that explained then. The financial records came out. North Star, the consulting agreement. Vale Community Development, the deadline, the percentage fee, and eventually records showing Cynthia had authority over the consulting company S finances, despite using her brother S address on the registration. Now there was a financial motive tied directly to the project. Then came the subcontractor. By then, he had retained his own attorney and begun cooperating with investigators. His sworn statement was simple. Cynthia had never sent him a message saying, "Burn Daniel Mercer's house." She was more careful than that. What she told him was, "Make the property problem disappear before the permit deadline." Those were the words I mentioned at the beginning. According to his statement, he understood the goal. If the house became badly damaged, the property could be portrayed as unsafe. It might be easier to condemn, easier to pressure me into selling, and easier to fold the needed land into the Pavilion project. Cynthia S. attorney turned toward her for the first time that morning. He had nothing to whisper. Cynthia tried to explain. The contractor had misunderstood her. The voicemail had been taken out of context. The survey had been prepared by professionals. The reduced offer after the fire had been an attempt to help me during a tragedy. My attorney didn't raise his voice. He asked for one final document to be displayed, Cynthia's email from the morning of the fire. Given the unfortunate condition of the property, the board remains prepared to acquire the parcel immediately. Timestamp, 9:14 a.m. The judge looked at the email, then at Cynthia. Then at the timeline, that was the moment the room changed. Before that, Cynthia still looked like an HOA president arguing over development access. Now there was a threat. A financial motive, a contractor, a suspicious payment, a damaged camera, accelerant, a fire, and an immediate attempt to buy the burned property at an even lower price. The emergency access request was denied. The disputed survey was sent back for county review. Records connected to the project were ordered preserved, and the criminal investigation continued separately. Cynthia was not dragged out of the courtroom in handcuffs that morning. Real cases do not always end with a dramatic arrest on cue, but she had walked into that courthouse believing she was about to take my land. She walked out knowing the land was the least of her problems. The robe shocked her. The evidence broke her story. Within a week, 3 Silver Ridge board members resigned. The remaining board suspended Cynthia and later removed her as president. Every fine issued against my property was canceled. The private survey was rejected, and the county confirmed in writing that my boundary had never moved, not 1 inch, without my land. The Pavilion access plan failed. Without the project, the consulting agreement became worthless. Civil claims later forced the association to account for money spent on the failed development plan and reimburse costs connected to the property dispute. Investigators continued following the contractor payments. The false records and the fire. I didn't attend every proceeding after that. I didn't need to. I had spent enough time watching Cynthia confuse authority with ownership a year after the fire. I rebuilt. The new house was smaller. I kept the stone chimney that survived the flames, and along the southern boundary, exactly where my father's survey said it belonged, I installed a simple sign. Private property. Boundary recorded with county. The new Silver Ridge Board adopted financial disclosure rules, independent review for major contracts, and a requirement that county records be checked before the HOA asserted any property claim. They asked me to join the board. I declined. I was part of their HOA before Cynthia arrived. I had no reason to become part of it after she left, but I did help organize a small workshop for homeowners on something much less exciting. Deeds, surveys, insurance records, photographs, backups, because people who abuse small amounts of power depend on everyone else being too exhausted, too intimidated, or too disorganized to challenge them. Good records change that. Cynthia had a title. So did I. But a title can give someone authority. It cannot give them ownership, she thought. Burning my house would erase the line between her land and mine. In the end, the fire made that line impossible for anyone to ignore.